and I just want to make a few points about the learned intermediary doctrine. First of all, there are certain things it doesn't do. Number one, the doctrine does not excuse a pharmaceutical company from giving adequate warnings about its drugs. It doesn't have an absolution from duty. It has the duty to make those warnings available to the people who have the power to decide whether the drug should or should not be available to the consumer. Number two, the doctrine doesn't excuse a pharmaceutical company from avoiding false and misleading statements, even by implication, when it elects to speak to consumers. So, for example, and I think you've talked about litigating it, if advertising doesn't have fair balance, as the FDA would say, if it neglects the major statement of side effects, if it doesn't make adequate provision for a consumer to learn more, the pharmaceutical company is liable for the people who rely upon that advertising and are misled to their detriment. So it doesn't excuse, it's not a free license to say whatever you want to say. I think those are important points to bear in mind. And three, we talk about direct-to-consumer advertising, but there are 11,000 approved prescription drugs. And I think the count of advertised drugs is very different from the count of approved drugs. And in fact, in the case we were discussing, the Wyeth versus Levine case, a great deal was made of the fact that there's a huge battery of approved drugs out there, and even the FDA can't keep track of them. So the fact that a few drugs are advertised really doesn't say that drug companies are out speaking to the public at large, trying to figure out who might or might not take their drug. And if you look at the methods by which drugs are dispensed, you go to the pharmacy and they're taking them out of a bulk supply and putting them in pills. The drug companies have fairly limited resources in dealing with advising the public at large, and especially before the decision is made. It's one thing and another to be told once you've got the prescription, but how are you going to be told at the point that Janet's talking about, when you've got to decide whether you should take the prescription, whether you should accept the prescription? Because once prescribed, it's very likely you're going to do it. So I think we're vastly underestimating the practical real-world question: how would drug companies dealing with potential users tell them all about it? Now, they do post it on their websites, and if you really are interested in investigating your prescription or asking your doctor, why are you prescribing this when I've heard about the side effects, there's very little that limits you to do it. Okay, let me just deal briefly. Janet has said properly, there's a long history to the learned intermediary doctrine. Most people would date it from 1966, when it was articulated in those words in Sterling versus Cornish by the Eighth Circuit. And the classical formulation is that a drug which otherwise might be unreasonably dangerous saves itself from being unreasonably dangerous if adequate warning is given. You might say, well, what's the sense of that? And the sense of it is, it goes back to comment K in 402 of the second restatement. Drugs, as Dr. Wolf said, can't be perfectly safe. They're powerful, they change your body chemistry, they're going to have inherent risks. So in terms of strict liability, you have to recognize that you can overcome the risk by a warning which allows a reasonable decision whether the drug's efficacy, whether its good points, are worth taking the risk. And the question then is, who makes that decision and who needs to be advised about it? One thing that's kind of a background to this is that federal law, since 1953, has distinguished prescription and non-prescription drugs. And a prescription drug is a drug which the FDA deems not to be safe unless administered under the care of a licensed prescriber. And what that means is the ordinary consumer, the ordinary potential patient, can't get the drug unless somebody gives a prescription for that drug. So there's a square responsibility. You can't get it. It's not like an over-the-counter. You can walk in and get it. You can't get it unless a doctor or another licensed prescriber says, yes, you should have it. So we have that background. It is not the ordinary consumer product. You are not entitled to go and get it. You can ask, and you can certainly say to a physician, I think this might help me, but that physician has a duty to explain to you whether A, you have the condition that the drug treats, and B, whether this drug is on balance going to help you. How they do that is really a matter of regulating physicians, not pharmaceutical companies. So that's one key point. The second is, because of the way that the law operates, there's a necessary causality question. You can't get the drug unless a physician prescribes it. The question then becomes, That's part of the chain of causality. Call it proximate cause, you can call it, it's called by many names. But you have to ask the question, was the information, which is the claim defect, the failure to warn, significant in the physician's decision either to prescribe or not prescribe the drug? Would it have been different if there were that additional warning? That's an important question because, as Janet said, often physicians will say, whatever that information might have been wouldn't have changed my decision, either because A, I don't read labels, B, I know more than the labeling, or C, on balance, this patient was in a condition where the risk was well worth running. You certainly have that. I think we talked this morning about cancer drugs. They're deadly. They kill cells. It's the only way you know how to treat cancer. But doctors say, use it because the alternative is worse. Well, in those situations, what is the patient expected to do? Are all patients really capable of participating? Does the patient really understand anti-cancer drugs? There are some drugs they can understand. They may be advertised. The condition can be understood. But in many cases, that's just not true. They can be advised. Their informed consent can be sought. But it is not expected that the patient will make the decision on how to balance risk and benefit. That's the job of physicians. That's what the learned intermediary doctrine recognizes. Now, I think that the three cases that have said this doctrine doesn't apply, and you can count any different way how many states have adopted the doctrine. There are probably, I think by now, 24 where their highest courts have said, yes, the doctrine applies. There are a number of states in which federal courts have predicted that the highest court would say it applies, and there are a number of states in which there are intermediate appellate decisions recognizing the doctrine. New Mexico was one of them, which have not yet gone to the highest court. But it's quite prevalent, and it's been recently re-endorsed because of the sense that the drug, when you come to really say, what is it? Is it a consumer product which doctors somehow become your agent for purchase of? Or is it a tool of medical treatment? Is it one of the alternatives? We talk about diet, we talk about exercise, you talk about surgery. Drugs are now part of the toolkit for a physician to use in treating you. And when we understand that, you can see the basis of that doctrine. It isn't necessarily intermediation, it's that the person who's making the decision, like any other treatment, has a responsibility to advise you about that treatment to the extent that he or she thinks it will be in your health interest. We know there are cases where a doctor will say, I didn't talk about that side effect because on balance I thought the patient needed the drug and I thought compliance was essential, and I was concerned that if I said too much, I would be harming rather than helping the patient. This is particularly true of SSRIs and other drugs where the psychiatric condition of the patient may preclude the patient from making the decision that the doctor knows is the right decision. And if we have a medical system and we have these intermediaries, I think we have to recognize their role. So if we talk about DTC, it sounds good and it sounds like, well, if you want to talk to patients, you got to talk to them all the time. As I said, there's a difference between fair balance in your advertising and assuming a duty just because you advertise of advising every patient of your 11,000 drugs that are available what they need to expect from a drug. And I think that in terms of DTC, as was said all along, it is probably one of the few things that really alerts patients that they should ask the right question. So it is, in a sense, beneficial, and it does impose duties, but putting those duties across the board because you advertise DTC doesn't make a lot of sense, number one. And number two, you really have to ask the question, is there a First Amendment violation? You want to speak, you have commercial speech is protected under the First Amendment, and suddenly say, well, there's a penalty. If you open your mouth, you will have a duty to talk to the world. So I think that when you look at the three cases, Perez was very much keyed to a drug that was advertised itself. The Carl decision, I think Janet said, was keyed to why should doctors in West Virginia have to abide by their duties when we can tag drug companies? They're richer and bigger. West Virginia has jurisprudence of that kind, so I won't comment any further.
That wasn't how I characterized it.
And the Rimbert decision really turned on a different concept, which was a strict liability concept. It's a repudiation of comment K. it kind of said, look, if the drug can harm people, then the drug companies who sell it ought to pay for it. That's a social justice concept that really doesn't have to do with who's advised or not advised. It's simply strict liability. It's saying, notwithstanding common K, if you sold the drug and the drug harmed somebody, well, you're going to have to pay for it. It's unreasonably dangerous per se. So I think I won't say any more, but I will reserve my 2 minutes.